Recording date April 26, 2007. The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15. The program airs on Sunday afternoon at 1 o'clock, and then it's repeated on Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com. My number is 276-3956, and John's number is 282-2672 for parents out there that need help when they get involved with the DHS, receive abuse reports, threats of losing their children. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI, that stands for Child Protection in Iowa. And as Don mentioned, one of our missions is to work with people on a one-on-one basis that are having difficulties. We're not attorneys, so we don't present ourselves as attorneys to do the practice of law. But we certainly have a few hints that we might be able to give to you. The other major problem that we try to attack is the business of influencing public policy as it relates to child abuse issues in Iowa. It doesn't appear as though our state legislature has done very much in this area. We'll be mentioning one of the things. We'll be mentioning something about their inactivity regarding the 2,000-foot rule. They knew they did something wrong, but they are not willing to make it right. And to me, that is a rather serious problem, not only locally, but I think when we have problems like that anywhere in the political system, we need to do some hollering about it. We've been working with a case that has some rather strange elements to it. It also has, unfortunately, some familiar elements because they are found in other cases. One of the things that you expect from a judge is that the judge not have a predisposition, or in other words, being prejudiced. I'm going to read you something that's written. It was a transcript from the judge. Had to alter it slightly to take out specific names, but it brought to mind some of the things that are wrong with our system, and that has to do with the judiciary. We're going to talk later on with Terrance Walker, and he's brought our attention to things of this sort. But this happened to be in a child abuse situation that has led itself finally to termination of parental rights. Termination of parental rights in juvenile court is roughly equivalent to a, well, it's worse than a felony conviction because it would be close to a death sentence in a state where death sentences are permitted, or life in prison without the opportunity of parole, or the chance of parole. Because once you terminate the rights, you sever the relationship between parent and child, that is forever. And they do that in juvenile court all too often. In fact, now they're cranking them out one after another and another and another. And I'm hearing about a few of those. Do you suppose the judge was prejudicial from the very beginning in this matter? This is a transcript of an initial child in need of assistance hearing. Some changes have been made to clarify and to remove references. It's the judge that's speaking, and she's saying, Mr. K, I trust that you will have a conversation with your client in regard to her concerns about her child. You see, her concerns were that her child was being sexually abused. Well, bureaucracy decided the child hadn't been sexually abused, so she's telling the attorney to instruct his client that she's doing some wrong thinking here, to hold a thought that is contrary to that of the wise judge. This is not having a good effect on the child, and that's why we are here today. This is what they call an adjudicatory hearing, is to determine whether or not the facts in a petition for child in need of assistance are correct or not correct. If the circumstances continue, she said, in the way that they brought this issue to the court's notice and caused a petition to be filed, this court will be seriously concerned about whether or not the child should continue in her mother's custody. What is this saying? This is saying we're going to look for every opportunity to find fault with this mother so that we can remove this child from this mother. I want to make that perfectly clear, said the judge. I'm very concerned about the child's mental health, as is Mrs. W. and Mrs. B. These are therapists that they had hired, and therapists are usually very compliant with the DHS who hires them. Otherwise, that will be the end of their therapy career as far as DHS is concerned.
Their money.
That's correct. If there are genuine and legitimate issues, they should be brought to the attention of the social worker. But this child has developed some pretty serious issues, and I have grave concerns about them, Mr. K. So speak with your client, because this court would consider a change in custody if we have a continuation of the issues that brought this court's attention. And that does not necessarily mean, because I don't know the father of the child, and because I don't have great information regarding him, that might not be the person that the child is placed with. Boy, she seems to know an awful lot about the child, and there haven't been any pleadings yet in court. This is the initial adjudication, the first step in the juvenile court to determine the truth of a matter. And it appears from this transcript that this person knows far too much about the case to be non-prejudicial. Do you suppose that it is a coincidence that the child's removal was based upon the potential harm of mental abuse? Well, the judge has already speculated about that. What are some of the serious issues? What are the grave concerns about them? It seems the judge is designing a scheme and planning just how the story will end once she's able to deny this mother access to her child and plot the other elements, such as removal, clues to mental injury of the child. Is it okay for it is okay for a novelist to plan and plot and design just how each scene will appear, but this is not the stuff of which serious judicial temperament should be guided. So that's you'll hear a little more about this case as it's taken to the Iowa Court of Appeals. So keep that in mind.
What you were reading there, uh, I thought it was. Oh, excuse me. Go
Hmm.
ahead.
Go ahead.
Well, I don't know
Go
what
ahead
you.
with your question.
Oh,
You said so,
never mind. That's
I
all
was just
right.
trying. I was just trying to get a picture up on the screen. Okay. You said seems to think what now?
You were talking about you were reading that case a little bit ago, and I was thinking of another case, and as you finished up by it, and the letters, the names of the parties are different, and yet it's very possible that the judge is the same person. I don't know, but the judge is thinking the same, going from one case to another.
Oh yes. In fact, I'm of the opinion that they just simply change the names in these stories. They seem to uh, simply say the same thing in every case, cite the same cases from case law, and simply change the names and birth dates to fit the new situation. Let's take a real quick look at the steps um, for a. I don't know if you can see that on the screen or not. I hope you can. Um, First, there is what is called an assessment intake. That's when social workers do their reporting, okay, their child abuse reporting. And then there's something called reasonable efforts. They'll dream up some kind of scheme of things that you should be doing in order to get your child back in your home or to keep from removing your child. The next step may or may not be uh, uh, issued, and that's called shelter. And the next step is removal. By the way, we saw a court project that is underway right now, and one of the issues in that court project was how can we make the removal of children from their home less traumatic? Well, come on now. You're engaged in something which is in and of itself is trauma written all over it, and you want to make it less traumatic. And I explained this to a group just recently. It would be roughly equivalent to sharpening the executioner's axe so that it would make the final execution a little less painful. Is this really what our courts should be doing? Is sharpening the axe? And that's what they're doing here with removal. Then we have something that was related to what we were talking about just a moment ago. That's called adjudication. Adjudication, right here. Adjudication is when you take a petition before the juvenile court and then you have a judge determine whether the issues in the petition are true or not true. So if a child is adjudicated a child in need of assistance, then he becomes what they call a China child, CINA. They call that China for short. And then once that happens, the next step is dispositional hearing. The dispositional hearing says, if now that we have determined this child to be a China child, then our next step is to determine what are we going to do about it. Will that mean a removal? Will that mean some kind of restraining orders? Or what will happen as a result of this child becoming a China child? And the next step is review, and they may have several of those. The next step is called permanency. We're going to look for a place for this child to be if this child is not safe with his own parents. And voila, they find that to be true in many cases. Find that children can't remain with their own parents because they have a better place for them, like foster care or adoption. Then the final step, and notice that all these steps are going downhill. So you can think of them as going downhill if your child gets in the clutches of the DHS and the juvenile court. The very last step is called termination. So the terminator goes to work here and separates parent from child. And quite often they'll even separate the children one from the other in these cases. Let's take a look. Reasonable efforts means that services must be offered to assist the family to keep their child safe at home within 60 days of removal. At the adjudication hearing and all other hearings, the judge must decide if reasonable efforts have been made to keep the child at home, to keep and to support returning home, or to make a permanent plan for the child who is not able to return home safely. And they've collapsed the time frame for all these things to happen in such a way that they're looking for a new place for the child at the same time that they're planning diligently to keep the child in his own home. Isn't that a tidy arrangement? Let's take a look at the next slide. Don, can we take a look at the next slide? This is, I guess this is just a change of the time frame where we have the assessment and the intake, and it's kind of hard to read that stuff at the edge. Child Protection Services.
Go right down through the center.
Yeah, we'll go right through the center here. Maybe we better. Okay, the assessment intake, that's the child abuse reports. Then we exercise the reasonable efforts, and I'd like to see reasonable efforts ever make any sense at all. They'll want you to take parenting training. They'll want you to take anger management training. They'll want you to take all kinds of things that interfere with your work schedule. And if you complain, they'll come back and say, what's more important, your children or your job? Well, I didn't know that you had to choose between the two. Sometimes it's pretty handy if you have children that you have a job.
So what does reasonable efforts mean in far as the court system is concerned?
What they should be doing is if they have spotted something where they can be of assistance in removing whatever the hazard is.
That's DHS.
Whatever the hazard is that brought you into court. For instance, drug treatment is probably a pretty good reasonable effort if they can get you off of the street drugs and hopefully off of pharmaceutical, supposed to be legitimate drugs. If they can get you off the drugs anyhow, that would be exercise of reasonable efforts to get the child back into your home. They usually choose up sides, though, between the female and the male in the home. And if they really like the male, you can bet that there's nothing that the female of the family can do to change their mind. So the fellow is in a good stead if he has the backing of a social worker.
And vice versa for the woman.
That's correct, and quite often these things stack up where the women get the advantage. Then we have the removal of the child from the home, and the adjudication, the disposition, the review hearings, and by the way, they allow you plenty of time for review hearings. I think it's 15 minutes. So your child is so important that he gets 15 minutes of the judge's time to do all these great things. Well, we get then into the permanency hearing, the termination of parental rights, and you get a chance to appeal. And Terrance has looked into this, and so have we at the appeals. And your chances of winning on appeal in the Iowa courts is close to nothing.
I've yet to see a termination of parental rights case where it's been overturned.
There are some, but
There are?
but they're very, like you say, they're very rare. And then we have adoption. And by the way, once that termination has taken place, you'll probably not have any access to your children at all. They'll want you to have maybe a goodbye visit, and you might be able to pack a suitcase for the child with their favorite things in them. But other than that, you're pretty much done.
What's termination of parenting rights mean in the long run?
Termination of parental rights is disassociation in every manner
Forever.
between parent and child forever. Of course, the juvenile court loses its jurisdiction at age 18, but if they've shipped the child to another state, you're not likely to see the child again after termination of parental rights. Okay, one more here. Okay. What's the role of the juvenile court? Isn't it interesting? Isn't it interesting what the juvenile court has done for us and to us? The purpose of the juvenile court is to protect the physical, mental, and emotional well-being of children, to help parents create a safe home for their children. See, we weren't able to do that 100 years ago. We had to have the juvenile court come in. Juvenile court is not a criminal court. However, information from the juvenile court, or, by the way, any information you give to your social worker, can be taken to criminal court. And thereby it comes in the back door as far as admissibility. So don't worry about it. Anything you say can and will be used against you in a court of criminal law. When does the juvenile court get involved? Well, when a child or family needs court-ordered services, when a child has been hurt or is in danger. The words usually are child abuse, neglect, denial of critical care. The court stays involved until the judge believes the court-ordered supervision is no longer needed. Don?
I question the sentence, when a child family needs court-ordered services, that's when the juvenile court gets involved. A lot of times they get involved when they are not needed, and it ends up just destroying the family.
Absolutely. In fact, the case I was talking about is one such case, and I think this is one element, Don, that I hear time and time again. We thought they were that when they said adjudication, they meant they were going to help us with something. That juvenile court, if we made them a China child, would come in and give us the kind of services we needed temporarily. Wrong. They have no intention whatsoever to give you the services that you need or desire for your children. They will not keep their place. They will do whatever they please in order to satisfy whatever agenda they're after. And you heard from that piece I read from the judge. That judge had already decided what the facts of the matter were. She didn't need any evidence because she had already decided that the child was going to be mentally abused because her mother wouldn't change her mind, that the child was suffering real torment as a 4-year-old, and the child needed the care and the help of the juvenile court. Generally, I try to put these things straightforward, but sometimes it's difficult not to sound antagonistic. What I'm attempting to do is to show the facts right from the transcript of what the judge said. I didn't change any of the verbiage of the judge, but it appeared in this initial session that this judge had already completed her rulings, and all she had to do is to wait until she could get all of her underlings in the Department of Human Services, the therapists and so forth. She went on to fire therapists that she didn't like and hire others that she did like. She did all kinds of things. Reminds me of a businessman in a TV program I saw one time who sat in his 45th floor office and had walkie-talkies in his hand. All of his employees were out in the parking lot, many floors below, and he could talk on his. And they were all dressed up like chess players, and he could move them from place to place and play his game of chess using his employees. What I see in the juvenile court reminds me of this sort of thing, where the judge can get on her walkie-talkie and move people, hire people, accept or reject reports whenever she pleases, and actually micromanage the entire case from the bench. Now, this is one sick session when you have a court so far out of bounds in a situation like this that I don't think we'll ever be able to bring it back into equilibrium, back into some sense of equity for parents. It may actually take a civil war before we're able to straighten things up. I don't know. Let's talk to someone who may have more of a level head on issues concerning the law. Let's talk to someone by the name of Terrance Walker. Terrance?
Thanks a lot, John, for having me on again. Yes, I'm the self-proclaimed judge of the judges because nobody else is doing it. And we do have to have a judge of the judges because everybody should be accountable to somebody or something. And unfortunately, there is no adequate systems here in place in the United States today to put judges in the accountability, under the accountability umbrella. So we have these so-called groups like the Judicial Accountability Judicial Qualifications Commission. Some of these bodies set up by states and even the federal Judiciary Qualifications Commission. But as studies have indicated, year after year after year after year, they're not doing their job and they're not disciplined judges. There are, however, some reasons to be optimistic, and I think that the people in the United States are taking over and taking things into their hands to try to pass significant measures like the Jail for Judges movement and some more. One organization which has done a significant amount of work in Texas called HALT, that's H-A-L-T. They're based out of Texas and they've done a lot. And HALT just recently announced their top judicial disability websites. Now, when a judge abuses his or her authority on the bench, legal consumers rely on judicial disability systems to investigate the misconduct and impose sanctions. Now, as research for HALT's upcoming Judicial Accountability Report Card recently uncovered, public access to information about these systems and the judicial complaint process is surprisingly limited. Take, for instance, here in Iowa, we have very little knowledge or very little information on what it takes, as shown in past cases, which would be a sufficient basis to complain a judge. We've got the very skeletal, I want to say skeletal, those canons, they call them judicial canons, on judicial qualifications here in Iowa, but they're so vague and they're so unenforceable because they're so vague, and they don't have a lot of history behind what they mean. Like take for example, one of the canons, which I believe says a judge shall maintain the appearance of propriety. Well, what the heck does that mean? Nobody knows. I mean, is it those comments that John Harvey was just saying that the judge said in court at a proceeding where the judge appeared to have a potential bias at the onset of proceeding? I mean, is that an appearance of impropriety? You know, we have no record. We have no case history to really go upon. So what HALT is basically doing, they basically are fighting not only for judicial reform, but they announced these top judicial disability websites where people can actually go and find past cases on similar criteria to examine whether or not a judge is doing their job incorrectly or unethically or not. And Susan Blonder, who's the senior counsel for HALT, says that in an era in which more and more Americans obtain resources online, we're alarmed that so many judicial disability systems are still stuck in the dark ages without websites. And this is, I believe, on purpose, because here in Iowa, we've got an extensive judicial website with case law and this and that. We even have the skeletal canons of judicial conduct on that website, which are basically about 2 pages long on the website. But we can't go and examine prior cases in which judges were found to be unfit or unethical. Half a dozen states, however, offer websites to serve as valuable tools for filing a complaint against an unethical judge and understanding the judicial disability process. Websites for judicial conduct commissions in 6 states, Indiana, Pennsylvania, Texas, Utah, West Virginia, and Wisconsin, stand at the top of the heap. Taking top honors in HALT's national survey, the website hosted by the Indiana's Judicial Qualification Commission provides judicial disciplinary opinions dating back to 1986, including cases that led to private reprimands, a downloadable complaint form, explicit assurances that complainants may speak publicly about their complaints, and the disciplinary process, a detailed explanation of the process, and examples of complaints that would lead to dismissal, private reprimand, public censure, and removal. You see, in some states, you can't even speak openly about your complaint. One, I believe, was Nevada. Our friend out in Nevada, Las Vegas, Nevada, I believe Julie Alexander was talking about that. She's with the Redress Inc. movement out there in Las Vegas. Refreshingly, Pennsylvania's Judicial Conduct Board provides well-organized online information in an unusually consumer-friendly tone. The board's website, which assures the public that they have a right to expect the highest standards of ethics from judges, features a fact page that addresses everything from the kinds of allegations that the board will consider to the complainant's role in disability proceedings. Texas's Commission on Judicial Conduct offers one of the nation's most sophisticated websites and includes a section dedicated to the state's growing Spanish-speaking population. I wonder if that's the reason why is because HALT is down there pushing for these measures. In addition to providing bilingual information about the discipline process, the site offers a downloadable complaint form in Spanish. Unlike the state's ineffective lawyer discipline counterpart, Utah's judicial discipline website provides a goldmine of information as well. While online resources in other states characteristically lack clear explanations of the disciplinary process, the Utah Judicial Conduct Commission site offers a color-coded, plain language flowchart guiding consumers from the preliminary screening stage through the Utah Supreme Court's sanction recommendation phase. The Judicial Investigation Commission of West Virginia is unique in that it provides a comprehensive synopsis of advisory opinions dating back 25 years and divides them by topic, such as mistreatment of litigants in the courtroom and misconduct stemming from financial conflicts of interest. The extensive database allows the public to review the Commission's rulings in different kinds of misconduct cases as well. While most judicial disability bodies conceal data, Wisconsin's Judicial Commission includes detailed case dispositional data on its website, which allows the public to hold the system accountable for its rate of discipline. And this goes back to what I was saying. A lot of states, most states, have very, very, very few judges that they ever do discipline. Now, Halt is doing a commendable thing in pointing out these things, and I think that we should take it upon ourselves definitely to view the halt.org website. That's HALT.org, for those that have website access. If not, find somebody that has website access, because in this day and age, you got to be connected to the internet if you want to get some useful information, because it's not going to be handed to you in the paper nowadays. Did you have a little more time?
Yes, go right ahead.
All right. I had one little interesting tidbit. It's kind of an anecdotal story here, but I think that it has a really good point. This is by Joel Turtle out of the conservativevoice.com, and it's entitled, "I Don't Care What the Judge Said." Look, Mr. Strawn, John, can I call you John? We've been at this for 25 days. We're all sick of this. We all want to go home, and you're the only one left. You're the one keeping us here. I've got things to do at home. I got to work. I got to make a living. All of us do. The judge is mad as hell at us, and you're going to hang this jury. You're going to make this 3-month trial into a farce and waste of time. You have no right to vote for acquittal. You heard the judge's instructions. This jury is not allowed to judge the law, only the facts. Well, the facts are clear as day, aren't they? Dillard ranted. You even admitted that to us. The guy was found with marijuana in his car. That's against the law. And the guy admitted the marijuana was his. Why do you need more? Said Raymond Dillard, the jury foreman. Raymond Dillard was a tall, beefy guy in his 30s, and he was getting mad, so mad that he wanted to beat John Strawn's head in. Strawn was a small, slim man in his 30s with straight back, dark hair, large, steady eyes, and a firm mouth. He seemed not to care at all about the whole trouble he was causing, and he seemed to be fearless. John Strawn said, I don't care what the judge said. I happen to know for a fact that a jury has the right to judge the law. Jury nullification has a long history in this country. A jury has the right to judge the law, not just the facts. Raymond Dillard and a few other jurors sneered. Dillard said, are you a lawyer, Mr. Strawn? You think you know more than the judge. What history are you talking about? John Strawn said calmly, No, I'm not a lawyer. I'm an engineer, but in this particular case, I do know more than the judge. When I found out I was going to be on this jury, I did a little research about the history of juries just for the hell of it. Most people don't know this, but jury nullification has been upheld as a sacred legal principle in England common law for 1,000 years. Alfred the Great, a great English king 1,000 years ago, hung several of his own judges because they removed jurors who refused to convict and replaced these courageous jurors with other jurors they could intimidate into convicting the defendant on trial. Jury nullification also goes back to the very beginning of our country as one of the crucial rights our founding fathers wanted to protect. Our founding fathers wanted jurors to be the final bulwark against tyrannical government laws. That's why they emphasized the right to a jury on 3 of the first 10 amendments to the Constitution. John Adams, the 2nd President of the United States, Thomas Jefferson, the 3rd President and author of the Declaration of Independence, John Jay, the 1st Chief Justice of the United States Supreme Court, and Alexander Hamilton, 1st Secretary of the Treasury, all flatly stated that juries have the right and duty to judge not only the facts in the case, but the law, according to their conscience. Not only that, more recent court decisions have reaffirmed this right. In 1969, in U.S. versus Moylan, the Fourth Circuit Court of Appeals upheld the right to juries to judge the law in a case, and in 1972, the D.C. Circuit Court of Appeals upheld the same principle. Raymond Dillard said, well, if that's the case, how come the judges don't tell us that? That's because of this despicable Supreme Court decision in Sparr v. Hansen in 1895, John Strawn said. That decision said jurors have the right to judge the law, but that a judge doesn't have to inform juries of this right. Cute, huh? And guess what happened after this decision? Judges stopped telling juries about their rights. The judge knows about jury nullification. All judges do. But they hate letting jurors decide the law. They hate juries taking powers away from them. That's why judges never mention a jury's right to judge the law, and most judges squash defense attorneys from saying anything about it in court. Remember when Jimmy Sanders' defense lawyer started talking about it? The judge threatened him with contempt if he didn't shut up about jury nullification. And since you asked me, Strawn continued, I'll tell you a little bit more. Did you ever hear of the Fugitive Slave Act? Did you ever hear of Prohibition? Did you ever hear or know why those despicable laws were repealed? Because juries were so outraged over those laws that they consistently refused to convict people who violated them. They refused to convict because they knew that these laws were unjust and tyrannical, that Congress had no right making these laws in the first place. So, because juries wouldn't convict, the government couldn't make these laws stick. They tried for many years, but they finally gave up. So who do you think made this war on drugs? Or what do you think made this war on drugs we've been fighting for the past 60 years? It's the same as Prohibition in the 20s. It's the same principle. A tyrannical government is telling people that they can't take drugs, just like in the 20s. They said that people couldn't drink liquor. What's the difference? A tyrannical law is telling people what they can or can't put in their own bodies. Who owns their bodies? Are us or the self-righteous politicians? Does the government own your body? Mr. Dillard, do you smoke? Mr. Dillard, do you drink beer? Dillard nodded his head. Well, yeah, I do. Well, how would you like it if they passed laws telling you you can't smoke or drink a beer anymore? Would you like that, Mr. Dillard? Dillard looked at John Strawn, thought about the question, then admitted, no, well, I guess I wouldn't, Strawn. John Strawn turned to the others around the table. You, Jack? You said you're 65 years old. You like to play golf. What if they passed a law saying anyone over 65 can't play golf because the exercise might give them a heart attack? You, Frank, you said you eat hamburgers at McDonald's all the time. What if they passed a law saying fatty hamburgers give fat people give people heart attacks? So we're closing down all the McDonald's restaurants in the country, and they make eating hamburgers a criminal offense. You, Mr. Pelcat, I see you like to smoke. Everyone knows that smoking can give you lung cancer. How would you like it if they passed a law banning cigarettes? What if they could crash in the door of your house without a warrant to search for cigarettes in your house, like the SWAT teams do now looking for drugs? Mr. Pelcat, how would you like to be on trial like Jimmy Sanders because they found a pack of cigarettes hid under your mattress? Do y'all see what I mean? If they can make it a crime for Jimmy Sanders to smoke marijuana, why can't they make golf, hamburgers, or cigarettes a crime? If you think they wouldn't try, think again. They had Prohibition in the 20s for 10 years till they finally gave up. The only reason they haven't banned cigarettes is because there's 30 million cigarette smokers in the countries who would scream bloody murder. They get away with it making marijuana and other illegal drugs illegal because drug users are a small minority in this country. Drug users don't have any political clout. Raymond Dillard sat down in his chair as the others started talking among themselves. John Strawn started seeing heads nodding in agreement, thinking about what he had said. Okay, Strawn, maybe you're right. Maybe Jimmy Sanders shouldn't go to jail for smoking marijuana. Hell, probably most of us tried the stuff when we were young. Clinton said he smoked marijuana in college. Bush said he tried drugs in college. Probably half of Congress and their kids took drugs at one time or another. Okay, we agree with you, but what about the judge? He said we can't judge the law. John Strawn stood up. He was a tall man, but he stood very straight, and he looked very sure of himself. He looked from one to another of them. He said, if you agree with me, then I ask you all to vote for acquittal. You are not defending Jimmy Sanders' liberty, but your own. You're fighting a tyrannical law that's enforced by a judge who wants the power to control you. I told you that many juries like us in the past have disregarded the judge's instructions. They stood up for liberty against a tyrannical law. Are you all Americans here? What do you value more, your liberty, your pride as free man, or the instructions of a judge who doesn't want you to judge the law, precisely because he knows you'll find the law unjust? Will you stand with those juries who defended our liberty in the past, or will you give in to this judge? Here's another thing to think about, John Strawn said with passion. What if your sister or brother is on trial here? Do you know that if we say Saunders is guilty, the judge has to send him to prison for 20 years? I understand this is Sanders' third possession charge. You know the 3 strikes and you're out rule, don't you? The politicians passed a law that if a guy gets convicted 3 times on possession, the judge now has no leeway in sentencing. He has to give the poor guy 20 years in prison. What if it was your sister or brother on trial? Should they go to jail for smoking marijuana, for doing something that should not be a crime in the first place? Do we want to send Jimmy Sanders to prison for 20 years because he smoked a joint, hurting no one? Can you have that on your conscience? Do you know that there are almost 1 million guys like Jimmy Sanders in federal prisons right now as we speak for this so-called crime of smoking marijuana or taking other drugs? These men were sent to prison for mere possession. They harmed no one but themselves when they took these drugs. How can you have a crime without a victim? When does this horror story stop? It has to stop. I'm asking you all now to stop it here for Jimmy Sanders. The only thing that can stop tyrannical laws and politicians is you and me, juries like us. If we do nothing, we're lost. The country is lost. I'm asking you to bring in a not guilty verdict because the drug laws are unjust and a moral obscenity. I'm asking you to be all the kind of Americans our founding fathers would have been proud of, these same men who fought for your liberty. That's all I'm asking. John Strachan sat down and looked quietly at Dillard and all the others around the table. They looked back at him, and it seemed as if their backs began to straighten up, and they no longer complained about going home. They were quiet. They talked passionately amongst each other. 15 minutes later, they walked into the courtroom and sat down in the jury box. When the judge asked Raymond Dillard what the verdict was, he was stunned when Dillard, standing tall, looking straight at the judge, said, "Not guilty." Over the angry rantings of the red-faced judge, all the jury box looked calmly at John Strachan and felt proud to be an American. And I thought that was a wonderful anecdote.
That's a marvelous story on
jury nullification.
Fully informed jury association type of effort.
Exactly, and I think that we all should consider that when we do take on the role of jurors.
Right. You mentioned tyranny here, and of course the Fully Informed Jury Association says that this jury nullification is the last-ditch effort, the last vestige of justice that can be meted out to a person to award against tyrannical things. Let me tell you about a couple of what I believe is close to tyrannical things. We're going to call on Don in just a little bit to talk about the 2,000-foot rule and the fact that our General Assembly managed to put it together, but have taken a few years to learn that it wasn't a good idea, but for some reason can't disconnect can't undo what they already did. Going back to a couple of elements which I think we need to fight against. Number one, property tax. Enormous increases are being felt in the property tax area when I was expecting them to drop because property values are dropping. Now what they're saying is, well, the property values are dropping on the more expensive homes. So that's a good reason that the brilliant cardiologists and the lawyers and so forth, their homes will not rise in value because there is a dropping of their property tax assessments. So the poor people and the middle income people can pick up the difference. Well, I suppose it makes sense, doesn't it, to tax the poor people. There are a lot more of them. So apparently that is the scheme this time around. They're not going to they're going to differentiate when there is a drop in property values, overall drop. They're going to differentiate between the expensive homes and the less expensive homes. They're going to nail the less expensive homes with the higher percentage of property tax and leave comfortable those who would otherwise probably cause more complaint to the system anyhow. So property tax, you only have a short time to appeal that. I think they set it up for early June, but don't let the time get away. This needs to be looked at once again. Now I wonder what would happen. If they're going to discriminate between expensive homes and less expensive homes, I wonder if they couldn't also discriminate between homes that were painted colors or homes that are painted white. You see, if they're going to use the value of the home as a determinant, then it would seem like to me that they could pick any type of thing that they wished to discriminate. Okay, the second thing, and I'll make this a whole lot shorter, is called the destiny vote. You're supposed to vote yes for destiny. The answer is no. Vote no for destiny. It means another penny sales tax. And basically what it is, it helps those who are paying commercial property taxes, those who are in business that are making money. They want to escape that and put it on people who are spending the money. So don't let them fool you. That extra penny is not going to go for the purposes that they declare. They can promise all they want, but once they get the money, they do what they please. So a couple of warnings here. Okay, Don, I'll have you read just one sheet here. It has to do with some of the critics of the 2,000-foot rule. Don, would you let us know what Lee Rood of the Des Moines Register thinks in his article? Don?
Critics rake, Critics rake in action on offender law. Legislators need to fix a law that does more harm than good. This is written by Register staff writer Lee Rood, April 24th of this year. So this is very new. Iowa sheriffs and prosecutors on Monday blasted lawmakers for failing to roll back a controversial and politically charged law restricting where sex offenders can live. They're just afraid to take action, and the people of Iowa should be ashamed, said Story County Sheriff Paul Fitzgerald. It's absolutely politics at its worst. A legislative subcommittee examining possible changes to the state's sex offender statutes will meet at 8 a.m. today to mull what some hope will be a compromise before the end of the legislative session. Earlier this year, the bipartisan panel heard during a series of public meetings from a number of groups, sex offender experts, statewide law enforcement associations, prevention experts and victims who uniformly criticize the state law banning sex offenders from living within 2,000 feet of schools or child care centers. Residency requirement laws, which have been passed by more than 20 states, often in the wake of high-profile child sex crimes, pull well with the public, researchers said. But law enforcement officials and other experts counter that the restrictions offer the public a false sense of security. Iowa and other Midwestern states, they say, have found that many more offenders tend to lie about their living arrangements or cease reporting their whereabouts altogether. Several lawmakers said Monday that they thought the legislature ultimately would pass a measure prohibiting registered offenders from entering safe zones around schools and other places where children gather, as well as other law changes. But Senate Minority Leader Mary Lumbee of Marion said Republicans would resist any attempt to repeal the 2000-foot law, which went into effect in 2005. Lundby said her belief is that people do not support such a move. My message hasn't changed since the beginning of the session, she said. We will support additional spending for monitoring sex offenders and additional assessments, but people people across the aisle don't want them in their neighborhoods, period. Do you want me read any more, John,
No,
or do you want to comment?
There's a stack of comments over there in very large print. Yeah, that next stack. That's it. Okay. You want to put that up, and maybe you can read those comments once you. This is a comment written by a registered reader, and we won't be able to go through the whole thing, but why don't you go ahead and do what you can here, Don?
I have mixed feelings on this issue. I'm not a sex offender. I believe that sex offenders should be punished. But to what extent? Question. Yes, we need to have punishments that fit the crime, but before we can have the punishment, we also have to have judges, lawyers, and other jury members that are willing to listen to all the evidence, not just a little bit of it, and are willing to let the defendant live with the knowledge that they are truly innocent until proven guilty, which is what our laws dictate. My cousin was convicted of these crimes against the children, his children. The sad part is this: it wasn't him that did it. It was his ex-wife, and she turned it around to blame him so that he was out of her life. She wanted to run around with her boyfriend that she found while he was working his butt off to support his family. The evidence was clearly shown stating that he was innocent, yet our society has still chosen to convict him in court by jury. The evidence was beyond showing more than reasonable doubt. It was 100% dead on that he was innocent. Yet he is still in prison for a crime he didn't commit. Even his children told the courts it was their mother, but the judge wouldn't hear it. He dismissed the children's testimony as inadmissible, as well as copies of timesheets and actual statements from coworkers that he was at work during the time of the crimes. He was one of those kind of judges that has the mentality of they're guilty even if the evidence proves otherwise, so don't bother trying. Then to top it off, he got sentenced to 7 to 10 years in state prison, 10 years on the registry, and he lost the rights to his children. The last time he was allowed out of the prison was his mother's funeral 2 years ago, and that was it. Every time he goes up for parole, his public defender doesn't show up to even try to get it. Isn't that interesting? The court-appointed attorney won't even defend him. His public defender has also failed to pursue getting an acquittal through the appellate court system by not filing the paperwork in a timely manner. So my cousin is sitting in jail waiting for his release sometime in the next few years. It's all because his ex-wife is a worthless piece of trash. So my question to those who back the death penalty for this matter: how would you feel about supporting the death of an innocent man or woman? Would it make you feel it better? Before you say I have too much information, take a look at the facts.
Okay, we'll stop it right there, and maybe you can put up some telephone numbers here, Don, so that people have something to refer to. Here are some numbers that may be of help to you as you have your struggles with the Department of Human Services and the juvenile court. We trust that these things have been helpful to you that we've shown you today. And thank you, Don, and thank you, Terrance, for assisting here. We'll see you next